sure my ringer is up. That would be good.
Good afternoon and welcome to the Center for American Studies annual Constitution Day debate. I cannot tell you how thrilled I am to see all of you. Do you know this is the first voluntary in-person event since this whole COVID has begun? So this is really exciting for us. And part of that excitement has to do with our speakers. I'm going to introduce them in a moment. I'd like you to take a second and turn off or silence your phones, and please stay off them during the event. Thank you very much. Secondly, let me introduce myself. I'm Elizabeth Copper-Bush. I am co-director of the Center for American Studies here at Christopher Newport. Our center is dedicated to teaching America's founding principles in history, economic foundations, and national security policies. Every year, we host a Constitution debate to celebrate our history of free speech and civic discourse in the country. This year is the 15th anniversary of the Center for American Studies, so we have a capital campaign going to raise $200,000 in student scholarships, yes, for you all, as well as we're working on endowed professorships. So stay tuned to hear about our alums, hear about what our students are doing, and some special events that are starting in September. What is Constitution Day? Well, it commemorates the signing of the US Constitution in 1787 on September 17th. If you do math quickly, that means you know it's the 234th anniversary. This is also called Citizenship Day, a day to celebrate those born or naturalized as citizens, which brings us to the topic of debate this year. What does the Constitution have to say about immigration? And I could not be more excited to introduce our two debaters today. We call it the Battle of the Two Ilyas. These two esteemed gentlemen are equally well-statured, as well as often confused.
I'm taller.
You're a little taller, okay, all right, academically statured. And they have some similarities in their past that make this debate especially interesting. They're both immigrants to this country, both from Russia, both have similar cultural heritage. So I learned that they, as well as being confused with one another, happen to have very different opinions on immigration. I thought they could share those with us today. So let me introduce them and then I'll tell you the format and then I will hand it over. Professor Ilya Shapiro is Vice President of the Cato Institute, Director of the Robert A. Levy Center for Constitutional Studies and publisher of the Cato Supreme Court Review. Before joining Cato, he was Special Assistant to the multinational force in Iraq on rule of law issues and practiced at the Batten Boggs and Cleary and Gottlieb. Shapiro is the author of Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and Constitution. You can also already see they don't shy away from controversial topics. And also editor of 11 volumes of the aforementioned Cato Supreme Court Review. He has contributed to a variety of academic, popular, and professional publications, Wall Street Journal, Harvard Journal of Law and Public Policy, Washington Post. I could go on and on. But I don't want to take up their time. He also regularly provides commentary for a number of media outlets such as CBS News and others. Ilya Somin is professor of law at George Mason University. His research focuses on constitutional law, property law, democratic theory, federalism, and migration rights. You may have heard of his recent book, Free to Move, Foot Voting, Migration, and Political Freedom, and it's currently being updated as well. Democracy and Political Ignorance, Why Smaller Government is Smarter, and among others. I'm only highlighting a few. His work similarly has appeared in numerous scholarly journals, Yale Law Journal, Stanford Law Journal, Northwest University Law Review, and others. He's published in popular press as well, Washington Post, Wall Street Journal, and others, and also USA Today. And the list is unending for these two fine gentlemen. So we're going to flip a coin. I need someone to call the coin, though. Okay, what's it going to be?
We're going to call it in the air.
Heads?
Well, I'll call it in the air when it's in the air.
Oh, okay.
Heads.
It is heads. All right.
I'll receive.
You'll go second.
No, I'll go first.
You'll go first. Okay.
I was making a football joke.
So this is Ilya Shapiro will be going first. The format is that he'll have 15 to 20 minutes, and then Ilya Somin will respond in 15 to 20 minutes, and they each get 5-ish minutes. And then we have open question and answer. So without further ado, please welcome our guests.
Thanks very much. It's great to be with you. Thanks for having me. It was a nice drive down. Your campus is beautiful, and I'm delighted to be again. This is the first time on a panel on a debate discussion with my friend Ilya Somin. And you know, we don't disagree that much on immigration policy. Most of our disagreements are on the law, both constitutional, statutory, and otherwise. And I think we'll tease that out. But we're also very different personally. You know, Professor Bush said that, you know, we have similar background and whatnot, but that couldn't be farther from the truth, you see, because I was born in Moscow and Ilya Somin was born in St. Petersburg. So this is worlds apart, right? You know, he's the poet. I'm a hard-headed analyst of the law and of power politics. So I'm just going to tell you how it is, even if you don't like it, even if I don't like it, because this is one area which I love discussing, immigration law and policy, because it's a place where my policy preferences and my legal analysis diverge. And you should ask your professors to identify, especially if you're talking to law professors, identify an area of constitutional law or public policy where they think something is a good policy but unconstitutional, or lawful but bad policy, because that really shows whether there's any integrity to the analysis, or it's just kind of filling in your legal theory to match your particular preferences. But I'm sort of autodidactic on this topic. I've never taken a class in immigration law. I've never practiced immigration law, but I am one of the few people you'll ever meet who's naturalized twice. So I was born in Russia. We came over to Canada, took a wrong turn at the St. Lawrence Seaway, and I grew up in Central Ontario and naturalized there, and then came down to the US for college and law school. And now, like most immigrants, I do a job that most native-born Americans won't, and that's defending the Constitution. So again, I'm not an immigration policy expert or even an immigration lawyer, just a simple constitutional lawyer with the lived experience of an immigrant. Now, very briefly, this is where I think Ilya Somin will go more into, and where one of our points of disagreement is, and that's where there is a federal power over immigration regulation under the Constitution. There's a naturalization clause, but that speaks of naturalization, how you become a citizen. There's the international, the foreign commerce clause, but immigration isn't really commerce. There's the foreign affairs clause, which deals with foreign relations with other countries. Somewhat different, doesn't fit. There are historical cases that have justified various immigration regulations under all of these constitutional provisions, but it's just not right. I think it's more honest to find it in the plenary power doctrine, sort of as an incident of sovereignty. Every country gets to control its borders, regulate who gets to come in, that sort of thing. It's as implicit or not as judicial review, right? Marbury versus Madison confirmed that the Supreme Court gets to evaluate the constitutionality of acts of Congress. Well, similarly, it's sort of implied that a government gets to regulate flows of control its border flows of people, that sort of thing. Ilya Somin's going to say there's no explicit immigration regulation clause, which is true. And indeed, at the founding and after, basically, it was very hard to get to this country. You had to cross an ocean. I mean, nobody went through the Mexican desert. There weren't that many people there anyway. But if you got to the country, you could be there, but nobody was going to give you anything. You had to make your way, and as long as you weren't a criminal and things like that. Or eventually, in Ellis Island days, you were checked for public health, which makes sense. I mean, I'll get into this. A sensible immigration policy would, the only restrictions would really be for public health or criminal background, terrorism, that sort of thing. And that's why the naturalization clause was so important, because there was a distinction between foreigners who were here and those who were becoming American. But in modern day, of course, this is why it's hard to analogize a separate debate over birthright citizenship, why it's kind of hard to analogize because there was no conception when the 14th Amendment was passed under which birthright citizenship is constitutionalized of someone who is here illegally. Well, what does that mean? You either got here or you're not. You're either a citizen or you're not. I mean, that's a distinction, but in terms of being here illegally, that wasn't a thing, but it became a thing, just as control of international trade, which has its own clause, but here it's, as I said, plenary power doctrine. It's not a neat prescription. It's not, but just like we have, in addition to judicial review, eminent domain, the power that the government has, federal or state, to condemn certain property for the public interest, for the public use. That's nowhere stated in the Constitution, but it's a background because we see the takings clause that provides individual rights protections against that. I think it's a similar sort of form there. In any case, everybody knows that our immigration system is a mess, possibly the most screwed up part of the federal government, which is quite a statement, believe me, particularly coming from someone from Cato. But it's true. Far from just advancing bad policy, our current system lacks a coherent policy in the first place, because our system is a remnant of various half-baked reforms going back decades, a schizophrenic set of laws that don't advance any particular goal. If you tried to create procedures for how foreigners enter the country, how long they can stay, what they can do here, it would be hard to come up with something less efficient or effective than our current hodgepodge of often contradictory regulations. This immigration non-policy has led to a state of affairs that serves nobody's interest. Not the rich or the poor, not big business or small, not the most or least educated, not the economy or national security, certainly not the average taxpayer, except maybe lawyers, bureaucrats, and the private prison industry. I guess they benefit from what we have. And yet most people agree on the problems that we face from this dysfunction. So first of all, there are 10 or 12 million illegal aliens living in the law's shadow. And that always reminds me of the great Canadian-American actor John Candy's last movie, Canadian Bacon, where he played a paranoid sheriff in Buffalo that was afraid about the invasion from the north, convinced the White House to go on this public service ad campaign with the tagline, "Canadians, they walk among us," right? People living in the shadow, which isn't good for them. It's not good for the rule of law. Then we have an issue with scientists, engineers, researchers, businessmen with no path to a green card or citizenship or even a work visa. So we educate and then we send them back to India, China, Russia, or they go somewhere else, Canada, Europe, Australia, Chile. Have you heard of Silicon Valley? The tech sector in that country, it's basically a wholly byproduct of the American immigration system. There's also an issue with employers who are unable to find legal and reliable manual laborers despite high rates of unemployment. As Alabama and Georgia found when they put in about a decade ago various state level restrictions, crops rotted in the fields and things like that. Then we have border states and counties that face a disproportionate burden relating to the provision of social services and law enforcement. So it's not like, immigrants, legal or illegal, are all in one place or spread out evenly throughout the country. Certain places have greater benefits, greater burdens, that sort of thing. And then we have, of late, issues with asylum claims, particularly with families and children, and how do you deal with those? But Congress, for various political reasons that cut across party lines, has been unable to fix anything, regardless of the party in power and whether the president spent his own political capital to push immigration reform like Bush did or not, like Obama did not in his first term and then just decided to act alone through executive action. Nothing's been done. And then Trump's aggressive attempts to change the system accomplished little more than outrage civil rights groups and spark a flurry of legal challenges. Biden's signals going the other way then contributed to a crisis at the border. People thought, oh, now it's going to be easy and we'll just flood the border. None of this has actually addressed the underlying problems plaguing our immigration system, which have to be fixed by Congress, by the federal legislature. I'm a big federalist. I believe lots of things should be handled, most things should be handled at the state and local level. But immigration is one of those things that there's room for state flexibility in terms of state-based green cards or work visas, what have you. We can get into that. But in terms of, it's a country that has to control its own borders. We can't have, Utah and Arizona, each having different rules about who can come in from where and which border. Although I would say that if Arizonans really cared about socialists who are lazy coming in, maybe they should build a wall on their western border rather than their southern one. But anyway, even before Trump, state governments feeling tremendous pressure to address the consequences of the federal failure to meet the nation's immigration needs acted for themselves. Again, about a decade ago, more now. Arizona was the tip of the spear, but we saw various immigration-related laws passed in states as different as Utah, Georgia, California, Texas, and whether related to enforcement, work permits, sanctuary cities, or other types of policy innovations, Congress and the executive's abdication of their duty to manage our immigration system has spawned a host of federalism experiments that don't work too well because they can only nibble around the edges, trying to add new criminal restrictions, for example, because immigration is, with a few exceptions, a federal responsibility. And now, as far as the law is concerned, a lot of things that both states and the federal government have done are unfortunately legal. SB 1070 itself, Arizona's big immigration restrictions. For all the brouhaha at the time, most of SB 1070 went into effect. The federal government only challenged 6 provisions, 4 of which the lower courts enjoined, and 3 of which the Supreme Court affirmed in 2012. The most controversial provision, the show me your papers, that police have the power to check the immigration status, or are required to, of anyone who they've lawfully detained whom they suspect is in the country illegally. The Supreme Court approved that unanimously, at least facially, as long as there wasn't racial discrimination, that sort of thing. And that's because the federal government's theory there was that because enforcement priorities had changed, states calling into the immigration hotline were burdening federal agents. Well, that's kind of an argument for preemption, meaning federal law trumping, federal policy priorities trumping state law on the whim of the president or the Secretary of Homeland Security or whomever. State law can suddenly be unpreempted, then preempted again. That's not good constitutional law. That's not the way the Supremacy Clause works. If the federal law directly clashes with state law, federal law trumps. But if it's just a policy priority, then that's not how that works. Which isn't to say that Arizona's law was smart. In fact, we saw that Arizona was harmed economically. Workers moved out of their state. The housing market collapsed. Lots of other problems that are attributed to that law and a related one, LAWA. How much time do I have left? Is there a timekeeper? Are you going to hold up like 5 or 3? Sorry? 3 minutes? 8 minutes. Okay. Could you hold up like 2 or 3 at some point? All right. Thank you. I'm not going to focus so much on policy. Often when I do these debates, it's kind of the reverse. I'll be with like a restrictionist with whom I might agree more on the law but disagree on the policy, in which case I have lots of economic statistics and crime statistics. For example, immigrants, whether legal or illegal, are a net economic benefit. It's not even close. Crime rates are much lower for immigrants, including illegal immigrants. Anyway, this is not really disputed. Assimilation, unfortunately, immigrants do assimilate fairly well. Our assimilation engine might not be as quick as some other times, but to the extent that we have problems, it's because there are certain pathologies within American society itself. And so the communities that immigrants can assimilate into might have problems, but it's not that they become un-American or don't, by the 3rd generation. Political attitudes really aren't differentiated, for example, let alone language ability from the communities in which they reside. But anyway, that doesn't mean that we can accomplish any reforms at the drop of a hat or by waving a magic executive wand. President Obama said 22 times that he couldn't just legalize people, the dreamers or otherwise. The dreamers are kids that were brought to this country illegally and have never known another country effectively. But nevertheless, that's what he did in November 2014 with, well, first in June 2012 with DACA, which legalized the dreamers, and then in 2014 with DAPA, Deferred Action for Parents of American Citizens and Permanent Residents, which has problems of administrative law, statutory interpretation, constitutional power. That is, there are provisions that temporarily allow the suspension of removal deferred action is what it's called, of people who are in the country illegally. But you can't just create a new temporary status that's then renewable kind of as a bridge to somewhere, but Congress hasn't acted. So the bridge kind of falls because there's nothing for it to lean against on the other side. Unlike other times where deferred action has been exercised, for example, students displaced by Hurricane Katrina who are then out of status, or in the wake of humanitarian crises in Central America or Haiti or elsewhere that President Clinton was reacting to. Anyway, we have these temporary measures that are put in place. Eventually, either the emergency goes away or Congress regularizes, creates new statuses, and so that's all right. But that's not what President Obama was doing. He was creating new status out of whole cloth without any connection to future legislative action. And that's why I think it was lamentable. I wrote in the Washington Post how I would love to have the DREAM Act, or the legalization of the Dreamers, or more broad reform, but Obama poisoned the well on legislative action and actually was counterproductive to the whole project for reforming our immigration system. And Cato filed briefs. On the cover, it said, Cato, a couple other people, and other supporters of DACA against, or of DAPA for that matter, against the legality of those particular executive actions. Eventually, the Supreme Court affirmed an injunction against DAPA 4-4. That's after Scalia died, so the court left the lower court ruling in place. Trump then rescinded DAPA. He tried to rescind DACA, but Chief Justice Roberts rewrote the law, as is his wont, and basically said that he didn't jump through enough hoops. We kind of have a ratcheting effect, apparently. Every president has more and more power, and the subsequent president can't rescind that. During his first week in office, President Trump signed several executive orders relating to immigration, even before the rescinding DACA Supreme Court case. And this included ordering the construction of a big, beautiful border wall with Mexico, withholding federal funds from so-called sanctuary cities, temporarily banning entry for nationals of 7, later 6 majority Muslim countries, and indefinitely suspending the entry of all Syrian refugees. These orders met with immediate opposition, both legally and politically. They clearly were not lawyered up very well. You had Stephen Miller giving the legal advice rather than actual lawyers. That's not the way to run a lemonade stand, let's just put it that way. Eventually, the third travel ban was upheld by the Supreme Court. This is another point of disagreement that I have with Ilyas Somin, because the way the jurisprudence works, the Supreme Court is not going to second guess the executive on national security determinations, nor is it going to make base constitutional arguments on random stray tweets, when we know that things that Trump said or tweeted aren't necessarily what eventually gets lawyered up once he allows the lawyers to do their jobs. Sanctuary cities orders, this is largely where Ilya and I agree. That the federal government can't, after the fact, force states to enforce immigration laws if they don't want to. If that wasn't part of the contract they agreed to get their law enforcement funding or something like that, it has a whole host of problems, whether commandeering state officials that the federal government can't do, or adding new conditions, new strings onto federal funding. Anyway, lots of legal issues going on there. Ilya and I disagree more on sanctuary states. So California put in various regulations that arguably interfered with federal enforcement by restricting private actors and inspecting federal, not state facilities. That case eventually ended. California got most of what it wanted. I would have gone the other way on at least 2 of 3 of those provisions. Mentioned DACA rescission. I think the court, if it was going to do what it was going to do, that Trump didn't jump through enough hoops, then I think Justice Thomas in dissent was right to say that at that point the court had to evaluate whether what President Obama did was constitutional in the first place, because otherwise the court's saying, yes, we'll allow this potentially unconstitutional action just because you didn't cross the T's or dot the I's or issue the right memos. And as with respect to the big, beautiful wall, well, Trump's ability to do that without congressional appropriation is pretty limited. There are other issues with eminent domain and environmental regulation. And even if the reappropriation of certain funds from military construction or other things towards a wall is appropriate under the statutory text, which is questionable, then there's a whole issue of non-delegation. That is, Congress is effectively giving the president the appropriation power, which it's not supposed to. Supreme Court hasn't enforced the non-delegation doctrine in 80 years, but nevertheless, that's how I read the Constitution. And now Joe Biden is entangled with, DACA was again enjoined by a lower court, so we're litigating that again. His Remain in Mexico policy, court said he has to put that back in place. Again, these competing back and forth executive orders is not a good way to run an immigration system. Fundamentally, the problem we face is that Congress hasn't had an immigration reform, hasn't passed one in 25 years. It hasn't reckoned with the idea that there's no line to get into for people to apply to. I first immigrated, my parents, we came to Canada. We were refugees, but they also had a point system that if you spoke the language or had useful skills, you were more likely to get in. Other countries do it in other ways. We don't do any of that. It's largely family-based, but then it's largely kind of gamesmanship based on what kind of lawyers you have, how you work the system, et cetera, et cetera. And amnesty is kind of a misnomer. It's, any kind of immigration reform is always sullied as being an attempt at amnesty. There no serious reforms contemplate forgiving anyone who's committed any crimes. Instead, we're talking about hardworking people chasing the American dream. They're not becoming welfare queens. They're not even eligible for welfare until they become green card holders and not eligible. The people don't generally come here to become citizens. The only difference between being a permanent resident and a citizen is the right to vote. You're forever beholden to the IRS and serving on juries. I'm pretty sure nobody naturalizes for those reasons. That's part of the reason why it's been difficult to legislate reforms is because the Democratic Party only will settle for a pathway to citizenship, even though most people who come here don't care about that. They just want to live here and work and be free to lead their lives and what have you. But of course, if you're not a citizen, you can't vote. And so there's that poison pill on that side. The Republican Party, even though they agree with the Dreamers, generally agree with legalizing, those who were brought here as kids, don't want to give that away because that's their ace in the hole for leverage over other things. And so you have this complicated game theory where no reform
and that's
gets
about
done.
Time. So
okay, let me conclude by saying that sorry, I didn't see any time, but let me conclude by saying what we need to do is to liberalize the system and then crack down on those who ignore it. So if you screw up or go too long without a job, you lose your visa. But everyone gets a chance, and we should have lots of different kinds of flexible visas, not just kind of the rigid employment-sponsored things now with naturalization. Thank you.
I'd like to start out by thanking Christopher Newport University for organizing this event and all of you for coming, and the other Ilya for his thoughtful contribution to this debate. As you'll see, there's actually more agreement here on some issues than meets the eye, though there is some significant disagreement over several key points. At the very least, if you learn nothing else from this debate, you will learn how to tell the two of us apart, which in many situations is a serious problem. There's even an Ilya confusion hashtag on Twitter that chronicles all the instances where Ilya confusion has come up. A couple years ago, I wrote a blog post called Ilya Confusion, a guide for the perplexed, which tries to explain how to tell us apart. And hopefully after today, at least, you won't have that problem. I'm going to focus in my presentation primarily on three big picture issues. One, is there even a federal power to restrict immigration in the Constitution? And it won't be surprising to say that the answer is no, it's nowhere listed. Secondly, let's say that there is such a power. At the very least, I'm going to suggest it should be limited by all the same constitutional constraints that restrict every other federal power, like the Bill of Rights, for example. When the federal government regulates commerce or spends money or does anything else, they're constrained by the Bill of Rights. They're constrained by other constitutional provisions that protect other kinds of individual rights. Nothing about immigration should be an exception to that, even though sadly, under current Supreme Court precedent, it is. Finally, I'll talk very briefly about federalism and sanctuary cities, because I think we actually largely agree on that. And while most of the argument that I'm going to present to you is based on the text and original meaning of the Constitution, at the end, I will say something about how non-originalist considerations play into this debate. Not everybody is a constitutional originalist. If you're not, you also have some reasons to agree with me on these key issues of contention. So first things first, the title of this debate is, what does the Constitution say about immigration? And the answer to that is actually very simple: almost nothing. And the very fact that it says almost nothing is an indication that this power is not actually granted to the federal government. It's not like the founding fathers only enumerated a few of the most important powers and left all the details for later extrapolation. There's a long list of different powers given to Congress, including such minor things as establishing post roads, creating a system of weights and measures, and on and on and on. Yet there's no listing of a power to immigrate or to restrict immigration. That's not because they didn't think immigration would be an issue. To the contrary, many of the founding fathers expected there would be extensive immigration, and there already was in the 70s, 80s, and 90s. George Washington, in his orders to the Continental Army at the very end of the Revolutionary War, he said America was going to be an asylum for the poor and oppressed from all over the world. James Madison, Thomas Jefferson, other founders said similar things. So it's not that they didn't think there would be a lot of immigration, it's that they didn't grant the power to restrict it to the federal government. There are nonetheless people who claim that there are other powers listed in the Constitution that can be seen as including a power to restrict immigration. Ilya Shapiro mentioned some of them. The most obvious might be the naturalization power, but as he also mentioned, and I agree, and the founding fathers also agreed, all this does is enables Congress to grant citizenship to people who are not already citizens, but that's not the same thing as keeping out immigrants. And if you look at debates in the founding era, including over the very first Naturalization Act in 1790, they well understood this distinction. Similarly, one could argue that the power to regulate foreign commerce is a power to restrict immigration. Some people have argued that, but in the founding era and for decades thereafter, it was understood that the power to restrict commerce is a power to restrict trade in goods and services, to limit imports and exports and the like. And people, at least free people intending to migrate, are not goods and services. If you want to say that they are, then the very same clause of the Constitution also gives Congress the power to regulate commerce among the several states. So by implication, that same power would give Congress the authority to prevent Americans from moving from one state to another. And nobody at the founding thought that. Even today, nobody would argue that it has that authority. So you can't fit it into the commerce power. Some people would also say, well, maybe it can go into the necessary and proper clause, because there's this clause of the Constitution which says that Congress can enact any laws that are necessary and proper for carrying into execution other powers granted to the federal government. The Supreme Court has interpreted necessary in a very broad way as anything that's useful or convenient. I don't really agree with that, but I'm not going to try to debate it here. On the other hand, the court has said this as far back as Chief Justice Marshall in 1819. They've said that proper means a power that's not a great and independent power. So you can use the necessary and proper clause to tack on some minor additional power that's necessary to implement some other authority that's already listed in the Constitution, but you can't use it to tack on a great and independent power. I think it's pretty obvious that the power to restrict immigration is not just some small minor thing. It is in fact a great and independent power. I'm not the first person by any means to suggest that there isn't a general federal power to restrict immigration. People like James Madison, the father of the Constitution, Thomas Jefferson, and other leading founders said very similar things way back during the founding era when they had the debate in 1798 over the Alien and Sedition Acts. Today, people most remember this for the sedition part, where you can't criticize the president and other violations of freedom of speech were enacted. But the alien part was just as significant at the time, and that included an act which said that the president would have the power to expel any aliens he shall judge dangerous to the peace and safety of the United States. This led to an upsurge of protest, including by James Madison and Thomas Jefferson and others. Madison said the Alien Act exercises a power nowhere delegated to the federal government. And Jefferson and Madison and other critics of the act prevailed. For the next 70 years or so, there were almost no federally imposed immigration restrictions. It was generally agreed that such a thing would be unconstitutional. Now, some people argue, as Ilyas Shapiro does, that yes, nowhere is there listed a power to restrict immigration, but it's got to be in there somewhere, because all sovereign nations have a power to restrict immigration. We just would infer that that power exists. This runs into the problem that the founding fathers did list quite a lot of other powers in the Constitution that every sovereign nation is supposed to have: the power to tax, the power to declare war, the power to raise